No, I really hope that the only reason why people may not resort to violence in 2027 to Abika. Otherwise, go to Makauka. Why would we go to court? And he owns the court. Extraordinary.
The so-called inventory, Your Honor, that has been brought before you does not square out with the criminal procedure provisions taken. We are treated into a circus, Your Honor. You'll have the opportunity to analyze. No description of the under the criminal procedure code. Is it true, therefore, that the witness and the investigating officer, the 3 of the affidavit is interesting, that they seek to incarcerate the respondent so that they can investigate the offenses alleged under paragraph 3. Under cross-examination, and when the same paragraph 3 was juxtaposed as against paragraph 8, they have not yet formed the opinion of the specific offenses to answer. Why are we before you? Why are we before the anti-terror court? If this does not amount to weaponization, intimidation, and harassment. And therefore, if therefore that is a question, does that square out with the mandate of the ODPP under Section 4 of the ODPP Act? Are these some of the cases that can be said that we are pursuing this for public interest? If the ODPP would come before you, and of course you understand the reason why this affidavit is this nature, it was prepared and the application was prepared, and my learned friend has ably urged that point, by the investigating officer. If they have not yet formed an opinion of what the offense is for you, the names of the individuals who are purportedly under investigations are not even known other than the name of Evans Ngarenjiro. Paragraph 9, Your Honor, of the affidavit. Again, they were not to specify with certainty, clarity, and concise. Jerry, help me. Sorry, I'm from Kirinyaga. Concisely. Where they are interested in. Jerry cannot help. You look at the second schedule to the Constitution. We have counties. Nairobi, somewhere in Nairobi. This is what we are calling fishing expedition. You know, further to the issue of cyber forensic analysis, the witness confirmed and the DPP has admitted that there is no possibility that the respondents would interfere with the forensic investigation being undertaken at the DCI headquarters. And then even if we were to assume that there would be interference, then what is the integrity of the process? Who should protect that integrity? The respondents? How would they protect it? Formed of the reason for the continued detention through the state, application to have him held by the state must satisfy a double test. The first test, that is the first test. The test is not that of a compelling reason. Number 2, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action, rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice.
Be there to deal with, to lead everybody at Odieki because he's an old man now. So the young man who will be defending the Constitution needs to say something. Let them just...
So, Your Honor, I want to begin with a preliminary legal question that the current... Otherwise, a charge or a holding charge would have been preferred as against the respondent, all these items. So the only thing they require is for them the respondents need to be detained for this to proceed. So, Your Honor, and the big aspect of investigation, number 1, by taking witness statements, obtaining call data from applicants, and securing forensic. There was a decision that was quoted by the prosecution, that is Njao.
This undermine confidence in the rule of law and deter investment. several global companies have already left or scaled back operations. I would, when you have your time, Your Honor, look at that. But our strong submission, therefore, is this motion, this application by the ODPP is unconstitutional. Absolutely no reason to. Already their freedom, as I said earlier on, has been curtailed. They have been in detention these 3 consecutive days without a holding charge, as we heard from Mr. Sakimpa, or indeed any form of charge. So this whole thing is a political circus, an attempt to silence dissent in an otherwise open democracy, and unconditionally release Honorable Mukunji, the journalist, the border. In fact, the very fact that you have a border representative in court tells you a lot. Tells you a lot about our Kenyans. This is wonderful Kenyans. To go join their families and their constituents and enjoy their profession unhindered, because the Constitution, as Kungu has very strongly submitted, tilts in their favor.
The question before you is, the questions that are before you are very important, though not complex. As everyone is trying, councils are trying to make it. The question before you is, should the respondents be held in custody pending conclusion of investigations? And are there reasons to do so unconstitutionally? That is what you say, Council. I cannot make such a it's okay. We have laid before you the probable cause to believe why we should continue, that there is a probable cause to believe to allow us to investigate this matter. And we have also presented to you the reasons as to why it is important that the respondents remain in custody. And to cap it all, we wish this court to protect the investigations and preserve the integrity of the investigative.
Stopping the said arrest of the 2 suspects so as to upset the validity of the present case in respect to the 2. In regards to the 11th subject, this court does find that the prosecution acted outside the express provisions of the Children's Act, and in so doing, they risked occasioning a violation of the 11th subject's rights as stipulated under the Children's Act if such violations have indeed not occurred. And as such, I proceed to order that the 11th subject in criminal case number E068 of 2025 is hereby discharged from these proceedings, and to direct that the prosecution shall ensure full compliance with the provisions of the Children's Act vis-a-vis the said subject. Great exception are the manner in which the law enforcement officers chose to perform the exercise of their duty during the arrest of the 2 accused persons. The dramatic capture and removal of the accused person and the commotion which ensued did not help quell public tensions. The said actions are indeed counterproductive, and they diminish the confidence of the members of public in the judicial justice system. That being said, however, I am not persuaded that a person admitted on cash bail or bond cannot be arrested under any other circumstances until he has spent at least 1 night in his home, as was suggested by counsel. I find that although that conduct of the police left much to be desired, there was no legal impediment or lawful order stopping the arrest of the two accused persons. And as such, those actions, as flagrant as they were, do not overthrow the validity of these proceedings. And I have sufficient space to host all of them. I will therefore request to the side and allow those ones that have not answered just to be, but stay within earshot so that you can follow the ruling. Please go ahead and call out. We will take the quorum in answer first and then we'll proceed to...
That's when I say
Yes.
the appearance of the before agreed by
For the state, the quorum is as before.
Juni, Wanjiro, Sada Wanjiko Thiga.
Please rest. However, one thing to conclude that the courts must be sparing in their grant of relief to seek to challenge the DPP's decision to prosecute or from any such review. Decision of the Court of Appeal, the court went on to state as follows, and I quote, of the ODPP. The burden of proof rests with the person, it is already on the record.
Of typed proceedings
Yes.
to enable us to launch an appeal in the High Court.
Yes.
And they also indicated that to enable us to move to the next level,
Yes.
we await the finding of the High Court, and so that we are able to secure the liberty of the accused person. Because we wish to launch an appeal against the ruling or the ruling of the court and stretch the limits of our law and our courts. And since we are aware that there was a charge sheet that had been prepared by the ODPP to enable us to go to, we are already under the Terrorist Act.
The presumption of
They are taking a
innocence.
plea in respect to a terrorist crime.
It's okay. We will
So
proceed.
the suspects of terrorism can take plea
Yes.
of a terrorist crime.
Mnamo tarehe 25 mwezi wa 6 mwaka huu majira ya saa 6 mchana na saa 5 usiku, ikiwa ni katika sehemu ya Kikuyu inayopatikana jimbo la Kiambu, nyinyi pamoja na wengine ambao hawajaweza kufikishwa kotini mlisababisha kitendo cha kigaidi ambayo ilisababisha uharibifu wa mali, ikiwamo ni afisi za serikali na pia majengo, yakiwa ni pamoja na ofisi ya afisa wa kifungu cha nje wa sehemu hiyo ya Kikuyu, koti ya Kikuyu, ofisi za afisa wa jimbo ndogo la Kikuyu, ofisi ya chifu wa Kikuyu, kituo cha polisi cha Dagoreti, na pia afisi ya naibu wa kaunti wa Kikuyu, pamoja na afisi zingine na pia mali nyingine ya serikali ya Kenya. Mshtakiwa wa kwanza Bwana Daniel Wanyoike Njiraini, shtaka la kweli si kweli?
si kweli.
Mshtakiwa wa pili George Kinywa Mwangi.
Si kweli.
Mshtakiwa wa tatu Alex Ng'ang'a Mwaura. Mwezi uliopita mwaka huu majira ya saa 6 na saa 5 usiku, ikiwa ni katika sehemu ya Kikuyu inayopatikana jimbo la Kikuyu, kwa pamoja na wengine ambao hawajaweza kufikishwa kotini kwa kusudia na bila idhini yoyote, mliweza kuharibu mali ya serikali na pia majengo, ikiwamo ni ofisi ya afisa wa kifungu cha nje, koti ya Kikuyu, Lawrence Ochieng Wasawa, Jack Leterengoz, Jackson Lenguris.
Kuna yule ambaye angependa tutumie Kiingereza, tutatumia Kiswahili. Shukuru.
Mnamo tarehe 25 mwezi wa 6 mwaka huu majira ya saa 4 na saa 12 jioni, ikiwa ni kituo cha polisi cha Matu kinachopatikana jimbo la Machakos, ikiwa ni katika taifa letu la Kenya, nyinyi pamoja na wengine ambao hawajaweza kufikishwa kotini mlitenda ama kusababisha tendo la kigaidi ambayo ilisababisha uharibifu wa mali, ikiwa ni mali ya serikali ya Kenya na pia ofisi zake, ikiwa ni pamoja na kituo cha polisi cha Matu, uharibifu wa magari ya serikali, na pia mkaweza kumshambulia afisa na kumjeruhi pamoja na maafisa wengine, hiyo ikiwa ni mali ya serikali ya Kenya. Mshtakiwa wa kwanza Bwana Nzau Kaloki, shtaka la kweli si kweli. Mshtakiwa wa pili Charles Musyoka.
All the accused persons before this court, the bureau, they have to be before this court. They have denied the charge. In the affidavit, to pick among a few issues, is that among the reasons the IO thinks they should not be released on bond.
There is nothing that would change your satisfaction that these people will change once granted bail or bond. Exercise all the discretion that you have to ensure that and they will abide by any conditions.
Looking at the affidavit that has been referenced by my learned senior, we submit that we don't see any compelling reasons. Your Honor. Your Honor, the reasons that have been given, for example, in paragraph 11, that they need to do forensics examination and an analyzation of mobile phones. We don't need to have the accused persons in custody for the prosecution or the investigative agencies to conduct